Now we all say okay, and that means we consent to it. Is that what that means?
It does, and it means I remembered, which is
Okay, well
perhaps
that
even more important.
right. Very good. Well, while we're waiting for Lorianne, I'm going to have to leave at about 10 till 3. I've got a dental appointment just a few blocks away, thankfully, not far, but I will need to get there in time. So let's go ahead and get with the introductions. And hopefully by the time we get done with that, Lorianne will be with us. Oh, what?
Lorianne just emailed me. She's going to be about 5 minutes late.
Okay, fine, perfect. We will go ahead and do the introductions then. I'll call on people since we all are, I assume, are looking at different screens. That said, as we get new people, the configuration of pictures will change, I know. So if I miss you, I'll come back at the end. And it's nothing personal. It's just that you might have been lost in the shuffle of of pictures on the screen. So Amy, I'm going to assume that everyone knows who you and I are. And it's my pleasure to be chairing this work group. Looking forward to getting into the meat of it with you all today. Let's go ahead. Kara, you're next on my screen. Please, Kara Goldfarb.
Hi, everyone. My name is Kara Goldfarb. I am going to be working for Amy this summer. And so this is my first day with the Oregon Law Commission, here to mostly observe and just listen in on what the work that is that you're doing. So nice to be
here. Yeah, welcome. Susan's iPhone 2020.
Hi, I'm sorry about that. I'm Susan. I've been a member of the Oregon State Bar since 1996. I've been a practicing elder law attorney since then, and now I am an associate professor at Willamette School of Law, and I teach trust and estates, elder law, will and trust drafting, and I teach in the trust and estates clinic.
Great, glad to have you. Gabe.
Hi, I'm Gabriel Hansen. Same situation as Kara. I'm a UO law student here as a summer research assistant with the OLC.
Excellent. Welcome aboard. And Jeff with 3 Fs, Petty.
Jeff Petty. I'm the legal policy advisor for probate and protective proceedings with OJD. And I'm interested to hear more about electronic wills.
All right, as we all are. Yeah. Jana.
All right, clicked away from the screen instead of on the audio button.
Right.
You'd think. I'm Shannon Newell. I'm also with OJD. I'm in the government relations team. I am interested in this topic, and regrettably, we're still working on getting a judge to participate directly with this group. But hopefully by our next meeting, we'll have some.
Okay, very good.
Ready to go too.
Thanks, Jenna. Eric, our reporter.
Eric Foster. I'm a lawyer with Foster Denman down in Southern Oregon, and taking good notes.
Great. Lorena.
Hello, I'm Lorena Erland. I'm an estate planning and administration attorney out of Salem, although I do some other types of law as well. I apologize, I wasn't able to be at the first meeting. I was on a flight, so I'm excited to be here today and meet you all.
Great, good to see you. Chris.
My name is Chris Colta. I work at the Legislative Policy and Research Office in support of the House and Senate Judiciary Committees.
And you have time for this today?
I'm squeezing it in.
All right, good. Andrea, nice to see you.
Nice to see you, Lane, as always. Andrea Meyer, Director of Government Relations, AARP Oregon. I was a member of the bar in good standing until I resigned a few years ago with the version that's the one that you do not read about in the bar bulletin. But I always forget which one it was. One of the things, while I'm here on behalf of AARP Oregon, in some ways I'm really here on behalf of AARP. We are one national entity, and our folks and my expert consultants serve on the Uniform Law Commission or serve as panel observers. And so we participated in this one and many others. So I will be representing us and the overall organization's perspective on these issues.
Great, welcome. Tara.
Hi, I'm Tara Henderson. I work with Allen Trust Company. I'm also a member of the Oregon State Bar, and I am here on behalf of the Oregon Bankers.
Oh, good. All right, welcome. Matt Shrimp, your background is backwards. Matt, did you know that?
That would be the difference, I guess, between Teams and Zoom, or Zoom and
Okay.
not Teams, but whatever the other one is, WebEx.
Yeah. Okay.
Where one of them has to be backwards. I'll fix that in a moment.
Don't worry about it. I just
no, but thank you for telling me.
yeah.
On the other one, I have to select the one that's in reverse, and then it appears backwards to me, and it's very
Right.
disconcerting. So I am at Department of Justice. I'm an assistant attorney general there. I do a lot of work with in probate cases, both with the state as a creditor, as well as for the Oregon State Treasurer when they administer estates for people with no wills or no known heirs. And often the question of, is this a will, arises in those cases. So this is particularly relevant to that, and hopefully I'll be able to assist. And the state today is keeping you on your toes because you'll need to remember the difference between OJD and DOJ. So Judicial Department and the Department of Justice are two separate entities, and
Yeah, right.
but frequently the acronyms are confused. If
Yeah,
not,
you're right. All
substance
right.
is what we do.
Thanks, Matt. Especially when they appear backwards on the screen.
Yep,
It's
exactly.
especially
Extra
confusing.
challenge.
Victoria.
Hi, Victoria Blatchley. I am a fiduciary litigator here in Portland, and I am one of your Oregon Uniform Law Commissioners.
And Victoria, as you were on the ULC drafting committee for this act, so have a particular perspective and expertise on this from that experience. Welcome, Teresa Hollis.
Mute off. Hi, Teresa Hollis. I'm an attorney with Fitzwater Law, and I do a lot of estate planning and administration. So hopefully I can contribute some experience to this.
Sure you can. CCAR, sorry. Oh, you're also muted.
Lane, she said that she didn't have any outgoing, so she can't talk.
I saw that message come through. Sorry about that. All right. Well, if you get desperate, grab a Sharpie and write out a message and hold it in front of the camera or something. And Lori Ann, you have joined us just in time. So good to see you.
Hi.
Well, okay, we're introducing ourselves.
Okay. My name's Lori Ann Sills. I'm one of the attorneys at Legislative Council, and I will be helping you out with this draft today.
Excellent. You have helped us actually already with this draft. So good to see you. Okay, have I missed anybody now? I think I've covered everybody on my screen, but if somebody has joined late, is there anybody else? All right, then let us go then to the next item on the agenda, which is just a review of what you have. It's LC 4792 by identification. And Lori, I thought I would ask Lori Ann just kind of tell us what we're looking at here. You know, you have the Uniform Act, which we can get from the Uniform Law Commission website, and that's been distributed before our prior meeting. Now we have something very special, which is an Oregon version of the act. And Lorianne, would you tell us what we're looking at, please?
Yeah. So first I have to apologize. As I was going back through this to preparing for this meeting, I noticed a couple of typos. So
don't worry about it.
Apologize. It has not gone through our editing process, and usually our output is pretty good. So let's go ahead. Basically, this is really close to the language that's in the Electronic Wills Act. I just tweaked it here and there to align with Oregon's form and style, and also some cross references. And there are some policy decisions that you all are going to need to make about remote witnesses. And I think there was one more thing. I'm sorry. I'll probably get to it.
Yeah.
Did you have something?
No, go ahead. No, okay. Go ahead.
So section 1 is just the short title, Uniform Electronic Wills Act. Section 2 is general definitions. I didn't really tweak these very much. Section 3 is, again, this is almost verbatim from the Uniform Act. This is the law, choice of laws. And it says that Oregon law will control. Right? I apologize. We're in the last stages
I
of the
know you
legislative
are.
session. It's a little bit, I think it's broken my brain a little bit, just a smidge. So section 4 is choice of laws regarding execution. So it's as long as it's executed in compliance with section 5, then it will be treated as an electronic will under this act. And then section 5 is really the meat of this bill, and that talks about the execution formalities. And you will have some policy decisions to make about how to align these, whether to align these with Oregon's existing will execution formalities in Chapter 112. So basically it says that, are you wanting me to go through?
No, we don't need to,
Okay.
no, huh? Yeah, we'll
Okay.
get to those in detail.
In section 6, there are 2 different options. One is if the state does not have a harmless error statute, and the other is if the state does have it. I put both in here, but we would be going most likely with the harmless, it says harmless error, or 112-238 applies to a will executed electronically. Section 7 talks about how to revoke an electronic will. Section 8 talks about electronic, how to, for the electronic attestation, if we're going to allow that, remote attestation. And how that happens, it's got a form in there for what the affidavit has to look like. And then you've got the certification. Section 9 is certification of the paper copy. Section 10 is just uniformity, and this is kind of boilerplate for uniform acts. Section 11 amends ORS 112-235. This is Oregon's will execution statute to specifically discuss electronic wills. Section 12 amends 112-238. This is Oregon's harmless error statute. Section 13 amends ORS 442-141, and this is electronic witnessing. So that would apply. So basically, this is a little bit weird in here, and we can go over it. We need to do some dialing in of making these things all align. And then section 14 is transitional provisions, and then section 15 is just a catch-all to say that the headings on this are not part of the law. That's what we did as LC.
All right. So yeah, for those of you who have not been involved in thank you, Lorianne. Those of you who have not been involved in an Oregon Law Commission project that is working on a product of the Uniform Law Commission, it is standard. There are, as Lorianne mentioned, just style differences between Uniform Law Commission drafting and Oregon statutory drafting, and so it's common not only in Oregon but in other states as well to modify the format and style of a Uniform Act to conform it more closely to the law of the state that is adopting it. And so there you'll see, as Lorianne mentioned, that some of that has been done if you compare this with the Uniform Act. And then also, I appreciate Lorianne leaving open to us then choices that the Uniform Act invites states to make, options that it presents as part of the Uniform Act that allows some flexibility among the states that adopt this. So this one is pretty straightforward. There's not been a lot of redrafting. The policy choices, I think, are fairly straightforward. I thought today, and based on, if you recall at the end of our last conversation, those of you who were here, we agreed that we would go through the act, try to create a statutory framework that would be implementable, making the policy choices that we're invited to make as part of the Uniform Act. I know there are electronic will skeptics in the world, and some of them may even be on this work group. But we've asked everybody to suspend their disbelief for the time being as we get through the act and then we'll take a look at what we have, and really see then when we get done what we have in terms of an Electronic Wills Act here for Oregon. We're not anticipating a 2026 adoption on this. 2026 is a short session. There may very well be a limit on the number of bills that can be introduced in the 2026 session anyway. It may be hard to get in, but I also don't want to put any artificial pressure on this group to feel like we have to have something done in time for a deadline for the 2026 session. Now, we may get done quickly. This is a pretty straightforward act, but again, I don't want anyone to feel like they're under any pressure for that. So any questions just kind of about what you've seen? Because my next plan is to just go into the act on a section by section basis. And walk through it, identify the issues, work out the issues that we can. Sometimes we may flag them to come back, depending on how other later sections come together. And also understanding that this is not a speak now or forever hold your peace proposition. We really just kind of want to get through the act as best we can on a first-time basis, and then we'll come back. So don't feel like you have to wrestle every issue to the ground. If you do want to state, just issues or concerns as we go, you're welcome to, but we probably won't be spending a lot of time to get all the specific detailed issues nailed down this first time through. But we'll see. I'm happy to work with the work group as you all want to do it. You all know a lot about this area or you wouldn't be with us. So I'm happy to work with the group in terms of how you want to take this as we get into it. Any questions or comments? Otherwise, I think we'll start with the section by section reading and see how far we get today. And we will then pick up at our next meeting, and if we don't finish today, and we'll finish the act in however many meetings it takes us to get through it. Amy, any words of wisdom from the director or Eric from our reporter before we get into it? All right.
Good.
All right, there we go. Section 1, any comments? Okay, section 2. These are definitions. As Lorianne mentioned, these come pretty much from the Uniform Act, and I will tell you that having seen a lot of uniform acts, most of these are standard, I want to say boilerplate, but they are uniform definitions of most of these terms. But I welcome any questions or comments about any of the definitions in section 2. Raise your hand if you have a question. Also, if I happen to just be asleep at the switch and miss somebody, feel free just to speak up and say, hey, you forgot me. Lorianne.
Yeah. So I know the definition of electronic presence could be problematic. I know there was some confusion with another act that was adopted that used the same definition as far as what in real time means.
That's
if
right.
you recall that, Lane, I'm not sure.
That was remote notarization, wasn't it?
I think so. Yeah.
Yeah, I think it was. But go ahead. That was a very interesting issue.
I just wanted to make sure that you were all aware of that, and I can't remember right now what they ended up, they end up just putting that on the legislative record, what they meant? They didn't go in and change the definition, did they?
I'm looking up remote notarization.
We may have changed the definition.
Yeah, for those of you who aren't steeped in this, and I certainly was not, the idea is that even when we're all together on Zoom like this, there is a nanosecond of delay in our communication, and so is it truly real time? Or are we adopting a standard that technologically we cannot achieve? Wasn't that basically it, Lorianne?
I think so. I didn't work on that bill, but
you didn't. Okay.
That was Marisa James.
Yeah.
But for the next meeting, I can talk to her and ask her how that got resolved, if you'd like.
Yeah, I'm looking through. It's chapter 194. I don't see it jumping out at me, but yeah, let's do that. In fact, I would say, however we resolved it, if for the Uniform Notarial Act, I would think we would probably want to resolve it the same way for this, so we don't have two different standards and meanings of real time when we're talking about electronic things. Amy, did you have your hand up? Looks like you're looking at another screen. Have you found something?
I did. Well, I just wanted to, Heather Gilmore was on that work group, the remote
Yeah.
notarization work group. And I remember her talking about it at that work group. So she couldn't be here today. She's traveling, but she might have a recollection as well of the conversation.
Yeah. Oh, I remember the conversation perfectly well. I don't remember exactly how we resolved it. And you know, Lorianne, we may have done just that, but on the legislative record, that what we mean by real time is approximate real time in terms of how we are communicating today. But I don't know what brilliant person would recognize that as an issue. But apparently when you're talking about electronic communications, there's really no such thing as real time, because there is that moment of delay between now here and the process and the server in the server farm in India or something, and the time that it takes to get back to us all on our screens. Okay, good. That's good. Let's flag that as a very technical issue, but we'll want to make sure that since it did come up in the related Remote Notarization Act, that it comes up, that we treat it the same way here. Eric, yeah.
Yeah, in terms of the definition of will, I just want to point out that there's a definition of will in ORS 111, 111.31.
Okay.
31, and so I think those probably need to be synced up.
111.
111.
Oh yeah, that's in the general provisions for probate.
111.005, subsection 31.
Okay, Lorianne, let's make a note of that. Will includes codicil and also includes a testamentary instrument that merely appoints a personal representative or that merely revokes or revives another will. So I guess that's a good question, whether there's any purpose to be served in having a different definition of will in one act than the other. I don't think if we were to amend the definition of will in section 2 of this act, I don't think that would render it non-uniform. This definition probably comes from the Uniform Probate Code, I would imagine.
So
And
the only difference between well, the main difference between the chapter 111 definition and what's in here is the last clause.
Right.
So nominates a guardian or expressly excludes or limits the right of an individual or class, blah, blah, blah.
All right. Yeah, so we can decide whether that is important enough to add to our definition of well, we wouldn't do that. We wouldn't amend section 111 probably in this act. So let's keep that in mind. Does anybody have any thoughts just off the top of your head?
I don't think in general we should have two different definitions for the word
Right.
will.
Oh, I
I feel
agree.
like we should decide on one.
I agree. And I guess my sense is that the one in chapter 111 has served us certainly perfectly adequately for however many years it's been apart. And I don't see that additional clause in section 7 of section 2 being necessarily particular to electronic wills. It just needs to be just generally a definition of wills for all purposes. So maybe a little flag on here that we will probably amend section 2 sub 7 to correspond to our existing definition of will in chapter 111. Thanks for catching that, Eric. Rather than amending chapter 111 to conform to this, and I don't think we ought to have two different definitions of will in the statutes. Good. Anybody else? Jeff?
This might be a dumb question, but record means information that is inscribed on a tangible medium. How would you electronically sign something tangible?
Well, let's come back to that because I think record comes up in other contexts.
Okay.
Later in the statute. Yeah, this is a uniform act. It's intended to capture written documents the way we think of written documents, but then also to include electronic. And it seems to me there is maybe it's in the section where we talk about certifying a printed copy, where a record might come up again there in reference to an actual printed document. But yeah, you're right. That itself is not, it does not define anything electronic. That is pen to paper, basically. Or yeah. So let's watch for that as it comes up. Anything else? Yeah, Matt.
Jumping back to the comment about will being defined in the act, assuming that this might get incorporated somewhere into 111 through 117, potentially the act does not need a definition of will at all, because the definition in 111.005 applies.
Ooh, good catch. Yeah, good point. Lorianne, would you imagine this would get well, or would this go in 112? Probably 112.
We would need to add it. Right now, that definition doesn't apply because we're not this, I've not drafted this to add it to that series. But we can easily do that if that's the way that the group wants to go through with this. So the way the series works, so the definitions only apply to what the statutes say they apply to. And once you codify, this is for everybody else's benefit. I know you know this, Lane. Once you, in order for a definition to apply to a specific statute, you either have to specifically say that this is what we mean, this definition as defined in this section, or you have to add the new section to the list of statutes that that definition applies to. So that would be amending ORS 111.005, or adding this to one of those chapters.
Okay. Is that pretty much an LC decision? No, okay. I mean, but where the series goes, I mean.
Oh, well, you have to, selecting which of those chapters to put it in is a policy choice.
Yeah, okay.
Generally, as far as giving it a statutory number, that's what LC does.
Right. I sort of had in mind that this would probably go in 112, where we deal in chapter 112 with will formalities. And in that case, then does 111 limit us then? That says as used in chapters 111, 112, 113. So yeah, if we put this in 112, then I think Matt is right. We wouldn't need a definition of will in this particular act, because 111.005 by reference applies to chapter 112. And yeah.
And we just have to make sure that all of the other provisions that are in chapter 112, you want all of those to apply to the Electronic Wills Act.
Okay. All right. Something for us to watch for then as we go forward. Well, let's make a note of that we may not need will if this goes in chapter 112, but then that does raise other questions that we probably will. Okay. All right. Anything else on section 2? It's a good start. Section 3, law applicable to electronic will, principles of equity, and electronic will is a will for all purposes of the law of the state. The law of the state applicable to wills and principles of equity apply to an electronic will, except as modified by sections 2 to 10 of this act. Questions about that? Yeah, Matt.
Similar procedural point. If we are declaring that the law of the state and the more specifically the principles of equity apply to an electronic will, do we maybe also want to say that those apply to paper wills?
Yeah, that's a good question. Or without getting into amending the law relating to paper wills, Another option would just be basically to take out the reference to principles of equity and figure that whatever applies to wills generally applies to electronic wills. Yeah. What do folks think about that? And again, so this, the Uniform Act is drafted without reference to other states specific, to a state's specific laws. Whereas in here, where we add principles of equity, are we adding something here relative to electronic wills that isn't in statute?
Right. If we didn't say that, would principles of equity not apply? I mean,
yeah,
I'm not sure it needs to be said.
I think they probably would, or the worst case scenario, somehow we're creating a difference in the way courts interpret or approach electronic wills from how they approach paper wills, and that's certainly not the intent. So if we were to say the law of the state applicable to wills applies to an electronic will except as modified, that may be all we need to say. Folks think about that. Again, no decisions are final, but I think that's a good point. Jeff powers of probate court include equitable powers. You're right, that's already covered in the powers we give probate courts. Okay, I think probably then we would take out the reference to principles of equity in section 3. Yeah, Matt.
I would support that, but I'm also jumping back a topic to the definition of will and electronic will. And if we do incorporate this into 112, which would make sense to me, I think we would probably want to look at where the word will is used in the rest of 111 through 117 and decide whether that all needs to say will or electronic will.
Okay.
Skill spot, or if we're going to change the definition in 111.005 to say that a will includes an electronic will.
Yeah. Lori, do you have a drafter's sense of the best approach to that, or is it too soon to tell?
Give me 1 second.
Yeah, it's fine. We don't need to make a final decision, but it's a good point.
It's possible that it might be addressed in the amendments that I made to 112.235 once we get there. Sorry,
okay.
It's been a little bit since I prepared this.
Yeah, good point.
So, I'm not sure that, you don't, for example, if you look at section 11 amends chapter 112.235, and it says that a will executed in compliance with the Uniform International Wills Act or the Uniform Electronic Wills Act shall be deemed to have complied with formalities of this section. And we don't call out it's a will or a uniform, an international will when we talk about wills. It's just wills, and that we don't have to specify that it's an international will.
Right.
So I think you could get away with the same thing here.
Yeah. Okay. But good to raise that, Matt. Anybody else on this or anything else on section 3? So we are, I think, already made a pretty quick decision that we will dispense with reference to principles of equity in section 3. All right, let's go on to section 4. Choice of law regarding execution. And keep in mind here, this is important, I guess, because we do have other states that have adopted this. Not every state has. A will executed electronically but not in compliance with section 5.1 is an electronic will under sections 2 to 10 if executed in compliance with the law of the jurisdiction where the testator is physically located when the will is signed, keeping in mind that signed includes electronic signature, or domiciled or resides when the will is signed, or when the testator dies. Let's think about that. So this would be, I suppose, a state that has not adopted the Uniform Act, but has adopted a version of some, well, yeah, I was gonna say just for whatever reason, the states another state has authorized execution of an electronic will, but it doesn't comply with all of the provisions of Section 5.1. We're saying as long as it was executed in compliance with the law of the jurisdiction where the testator was located physically when the will is signed, or domiciled or reside when the will is signed or when the testator dies, then in that case, that will still be given effect in Oregon as an electronic will. Thoughts, comments?
I'm wondering about the when the testator dies section. Is that different than our current will rules, you know, the statutes that apply to what wills are valid?
Right.
Domicile resides when the will is signed or when the testator dies, whether they're domiciled or reside when they die. I don't know. My brain's not fully in place.
Well, you know, it's funny.
Victoria, what do you?
I was looking for a corresponding provision in Section 112 for paper wills, and honestly, real quickly before the meeting, I didn't find it. This is one of those strange things where we've all done it forever.
I've always told people that it's the law of the place where you are physically signing the document, whether you reside there or not, wherever you are, you have to comply with the law of that jurisdiction. So to have it be the law of where they are when they die is just, it strikes me as unusual, but I don't have any citations.
And that may be worth looking. That may be a uniform probate code. That may be language from the uniform probate code as well. And who offered? I didn't see it in the comment. It popped up. Just a drafting issue resides when the will is signed. It was a matter of tense, I think. In my comments, but that's a drafting issue. Yeah, okay. So physically located where the will is signed. Oh, okay. Is this it? 112-255, Jeff, you think?
This is lawful execution. The domicile of the testator at the time of execution or the time of the testator's death.
What was that reference again? Oh, there it is. Yeah, there we go. Well, there's the reference to death. Domicile of the testator at the time of execution or at the time of the testator's death. So we compare that to Section 4. We add physically located where the will is. And I guess the question here is, again, as a matter of policy, do we want this to conform with, should this conform with existing Oregon law relative to paper wills? And if that is the case, then we would do some revising in Section 4.
So if the choice is to add this to Chapter 112, I would suggest removing Section 4 if you want it to be the same. Rather than having it duplicated in both places.
What do folks think there? I guess I'm kind of realizing we're coming to a point here where we may see this come up in other contexts. Generally, I think my sense is that we would probably not want to be amending our general law of wills, but really rather fitting this within the framework of our existing statutes, in which case I think Lorianne's advice is just right. sense of that? Okay, Victoria likes it. All right. So as a matter of a policy approach, then we will do our best not to amend, not to incorporate different law relative to electronic wills than we have, except in terms of execution. Obviously, that's going to be that obviously is going to be different. But otherwise, in terms of interpretation, in terms of choice of law, in terms of validity, we'll follow what we have already in Oregon with regard to written wills, and not chart new territory with reference to electronic wills, or certainly not try to change the law relative to written wills in making this work. Matt.
And to return to your comment at the beginning describing section 4, this is what would be applicable to determine if a will, an electronic will that is executed not
Right.
in the manner described in section 5. And so essentially what it's getting to is if it's executed in the manner provided for in some other state.
Right.
And I think that is potentially what 112.255 already gets to.
Yep.
With the potential need for a 112.255 talks about well, it uses in writing.
Right.
And so if we were going to somehow incorporate it into there, we might need to address that, or but it does make sense to me to incorporate it into 112.255 somehow.
Yeah. So at least the standard is the same. Folks agreeable with that? All right, let's go on. We got about 5 minutes here. I'm almost hesitate to, well, let's just dip our big toe in and see how we do on section 5. This is sort of the heart and soul of the Uniform Act. Let's get through it. We'll probably not finish section 5 today, but let's see if we can just make any headway with it. 1, subject to section 8.4, and we'll get to section 8.4, and except as provided in subsection 6 or section 6, which is the harmless error. So disregard that for now. An electronic will must be a record that is readable as text at the time of signing, in paragraph B, signed by the testator or another individual in the testator's name, in the testator's physical presence, and by the testator's direction, and either A, signed in the physical or electronic presence of the testator by at least 2 individuals, each of whom is a resident of a state. So we're not going to be farming this out to Cayman Islands or something for people to be doing this as a cottage industry out there, and physically located in a state at the time of signing and within reasonable time after witnessing, 1, the signing of the will, or the testator's acknowledgement, or be acknowledged by the testator. Okay, that's if you don't sign it, then you acknowledge it. Okay. Immediate responses to this and how it compares with the sort of the standards for temporal execution and witnessing of wills in chapter 112. Anybody want to try and wade into this with about 5 minutes left? All right.
Actually, Lane, sorry, I'm trying to figure out how to raise my hand. And
oh, sorry.
I don't use Zoom. We always use Teams, so I don't know how to do it.
Okay.
I'll figure it out.
You did the right thing.
Okay.
Yes, Lorianne.
So this is the section that has a couple of confusing things and some policy decisions that need to be made. Primarily, it's about whether the will can be signed in the electronic presence of the witnesses, or if they need to be in the same place as the testator when they are signing it. Because right now we specifically do not allow electronic witnessing of wills.
Right.
Under ORS 42,
Yep.
141.
So I guess my question to the group is, given the close connection between this and remote notarization, should we again look at remote notarization for how we approach execution of wills? That's in chapter 194, in terms of physical or electronic presence.
And this is also an issue for subsection 1, little c, big B, which allows for the testator
Yeah.
to either be in the physical or electronic presence
Right.
of a notary instead of
Yeah.
witness.
All right. Well, I tell you what, we're not going to get this. Let's leave it at this. And I apologize for that. I just accidentally scheduled a dental appointment. Sometimes you do that by accident. Amy, when's our next meeting? We've got a schedule laid out, right?
So that was actually the last thing on the agenda today. It looks like we're not going to meet in July so that folks who are doing legislative stuff can all take a nap. And then we're going to start up again in August. And the day what we found from talking to folks a little bit is that Friday is the best from 12 to noon, or excuse me, from noon to 1. Sorry about that. And then it's just a question if anyone has a preference on first Friday of the month, second Friday of the month, third Friday, fourth. What I was gonna do is give you guys, give few days to send me an email and say, hey, the third Friday of the month definitely doesn't work for me. And then if I didn't hear from anyone, I was going to pick one and set it going through the end of 2025. And so it would be, August, September, October, November, December. And that's where we would just have that day and time scheduled on the calendar, and you get a bunch of calendar invites. So today is today's Monday. And let's say if I don't hear from anyone by Friday, I will send an email out to folks with a date picked, saying we're going to meet on the second Friday of the month or something like that, from 12 to 1, and that's what we'll do for the next 4 or 5 months. But we will not be meeting in July.
Okay. All right, that gives everyone plenty of time to review section 5. Also take a look at chapter 194. There is, again, I think there's some congruity between what we're doing here and what we did with remote notarization in terms of policy. And the other thing I think the important decision we made today that probably we'll stick with is that we will, as far as possible, otherwise conform electronic wills to the statutory provisions for regular wills. Except in terms of their execution and whatnot. So we made a little bit of progress there today on a good start. Welcome again, Kara and Gabe. Good to see you both. And we will enjoy Lorianne, good luck with the last week or so of session. I know it's going to be an exciting time. And the rest of you as well, have a good summer, the first part, and we'll see you in August.
And one more thing really quick.
Yes, Lorianne.
The statute in chapter 194 is 194-277.
Thank you. Okay, good.
And I will add one more thing as well. You're going to see an email from me in the next 36 hours with the recording of this meeting. The question about the Friday, for those folks who weren't here today. And if anything else pops up, I will include that as well. So there will be an email coming out in the next 36 hours once the recording is finalized and I've posted it.
All right, very good. Good to see you all. Thanks, everybody. And we'll see you in August. Bye.
Thank you.